Oh. Have we seen Richard Freeman? Everybody make sure your ringer is off or your phone is off. On the record in the matter of the people of the city of Lansing versus Richard Bruce Freeman, file number 20-01645. Councilor Pierce.
Good afternoon, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Assistant Public Defender John Lee appearing on behalf of Richard Green.
Okay, Mr. Freeman. Today was the date that was reset on this matter, and that's because you were supposed to undergo a substance abuse assessment. Has that been done?
Yes, sir.
Counsel?
Yes, Your Honor, I have received a copy of it.
Okay, and this was us addressing the violations from 2021. With the jail and the waiting room things. I don't see no video. Yeah. I just see he was undergo sentencing, he was supposed to do by the 14th, but he didn't do.
You were waiting for that.
I have a hearing, well, I have the probation officer's update. I'm just trying to figure out what happened on January 8th, because my note just says I remember them. January 8th, agreement.
Oh, sentence for the PDA. So it was, so it was a sentencing for probation.
Yeah. Okay, you can make allocution. I do have his update on the assessment.
Okay. As Your Honor can see via the assessment, it has been identified that Mr. Greenman has had an issue with opioid abuse disorder. He reports that he has been in communication with his probation officer recently, that he has had clean tests recently. He's been attending NA meetings 3 times a week. He is working with Victory Clinic to both receive methadone and therapy. He sees a therapist weekly. He is journaling daily. He has taken a lot of positive steps forward, Your Honor, including work. He works as a contractor and has been contracting with RSC Home Improvement to help provide for his 3 daughters and a granddaughter that all live with him. So he understands the gravity of the situation and has been taking many steps to address what he admits has been an ongoing issue for him, but hopes to have turned the corner and would like to continue the treatment that he is getting, and would like to be reinstated to probation with a chance to successfully complete probation.
Okay, does your client want to make a statement at all?
Just that I'd like to keep moving forward with all the treatment and things that I've been doing to take care of this issue. Appreciate the court's opportunity to move forward with this.
The impressions of the evaluator that at the time of your evaluation, you seemed fair or in fair condition. It did report indications consistent with what your attorney has stated here, and that is that you are meeting with or at St. Mary's twice a week. That's still accurate?
Yeah, I'm going, yes.
Okay, it stated that you did provide proof of that and that you provided proof of your income and your testing at Victory Clinic. The court is going to reinstate your probation. It'll be for 9 months. You will continue your outpatient program to completion. You provide evidence of that to your probation officer, okay? He'll check in with probation once you leave here today. Do you have any questions today, sir?
No, no.
Okay. You are all set for today. We'll get you downstairs in just a moment, okay? Any additional matters for the record? Counsel?
Nothing for the defense.
Thank you. You're all set. Everybody on James Nicholas? On the record in the matter of the people of the city of Lansing versus James Ryan Nicholas, file number 23-01691 and 23-03242, counsel appearance.
Assistant City Attorney Amani Williams appearing on behalf of the city of Lansing.
Assistant Public Defender John Lee appearing on behalf of James Nicholas.
Okay, Mr. Nicholas, can you hear us?
Yes.
Okay, I have 2 files. One is a failure to obey, and the other file ending in 9-1 is for trespass. How are we proceeding on these?
There has been an offer extended to Mr. Nicholas. However, we have not had an opportunity yet to discuss it.
I'll reset this matter. Are you being held on something else, sir?
You said what?
What are you being held on?
Huh? I can't hear you.
What are you being held in the jail on?
This charge or not? I think failure to show up to court and methamphetamine charge.
So you have a bond on these and they're very low, so you're not being held on this.
He has a pending case of
Oh.
possession of meth.
Okay, so it says bonds $100, 10% on this. Okay, so we'll reset this matter. Are you going to visit him in the jail to talk to him about this?
Yes.
April 1st at 10:30.
April 1st at 10:30 is your next court date on these files, okay?
All right.
You're all set. Stephen Page present.
Yes, ma'am.
On the record in the matter of the people of the city of Lansing versus Stephen Paul Page, file number 24-00357. Council appearance.
Assistant City Attorney Amani Williams appearing on behalf of the city of Lansing.
Assistant Public Defender John Lee appearing on behalf of Stephen Page.
Okay, Mr. Page, today's the date that's set for a pretrial and disturbing the peace. Is there an offer extended on this?
There has not been an offer extended yet, Your Honor. I have recently come into possession of some documents pertaining to Mr. Page's situation that I think will be relevant to plea negotiations. So perhaps a short adjournment to allow for that. We should have a result.
Okay, we'll reset it.
April 1st at 10:30.
April 1st at 10:30 is the new court date. Do you have any questions today?
No, ma'am, Judge. Thank you.
We'll get you a copy of your notice to appear. Any additional matters for the record?
Nothing further, Your Honor.
Nothing for the defense, Your Honor.
You're all set, sir.
Thank you, Judge.
You're welcome.
Get a notice here in a second.
Dominic Salazar here.
Yes, Your Honor.
Okay. On the record, in the matter of the people of the city of Lansing versus Dominic Salazar, file number 23-00201. Appearance for the record.
Assistant City Attorney Amani Williams appearing on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Dominic Salazar.
Okay, Mr. Salazar, today was the date that I reset your matter for hearing.
Thank you for understanding the sickness of me and my child, Your Honor. I appreciate it. I'm here in person today.
You were arraigned on probation violations.
Multiple.
Correct. So it appears I have some more now. Previously,
Miss, I
yeah,
did.
I didn't give you an opportunity to speak.
Sorry, Your Honor.
Previously arraigned on failure to do random testing on November 6th, November 19th, December 3rd, December 17th. You pled not guilty to those violations. I opened the file and discovered that your probation officer left multiple notes here. States here that you failed to appear for your scheduled testing on February 26, 2024. Says defendant has continued to miss every drop. You've missed 13, you've completed 9, it says. It says he has not dropped since December 28, 2023. Spoke with defendant on February 14, 2024. Your probation officer said you advised that you will not miss any more tests, but then you missed February 18th and February 26th. It says that you had not provided documentation of a positive COVID test. It states you have not provided verification of AA. It says you're currently suspended from counseling at Reality due to missing tests, no verification that you have been remaining clean. There's another note that says defendant continues to miss even after adjusting test times to allow afternoon testing due to work. It says on January 10th, 2024, employer provided work schedule. Defendant was not notified of change on this date. Have a notice of no show for your testing on January 18th, 2024. No show of testing January 21st, 2024. No show January 5th, 2024. No show January 8th, 2024. And then it says no show February 6th, 2024. Okay. No show January 29th, 2024. Are we having a hearing?
No.
You're pleading guilty to these violations, sir?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay. You understand your right to have a contested hearing on these violations?
Yes, Your Honor.
You understand that you have the right to require the city and the probation department to put forth evidence to establish whether or not you in fact violated your probation as alleged.
Yes, Your Honor.
And you're willing to give up your hearing today in order to enter a guilty plea?
Yes, Your Honor.
Anybody threatening you to get you to do that? Any promises being made to you to get you to waive your hearing?
No, Your Honor.
Okay, as to the multiple violations, I will not go down those lists again, but it sounds like you've missed every drop. How do you plead? Factual basis?
Thank you. Mr. Salazar, is it true that you were placed on a period of probation in regard to case 23-00201?
Yes, sir.
And is it also true that you were ordered as part of that probation to make random testing so that you could be tested for alcohol and or any other substances?
Yes, sir.
Would it further be true and accurate to say that you have missed several tests between December of last year and today?
Yes, sir.
Okay. But true that you did miss the test?
I have missed some tests, yes, a lot of them, more than once, more than twice.
More like all of them.
A lot of them, yes, Your Honor.
No further questions.
Any questions from the city?
It is satisfied, Your Honor.
Okay. The court is satisfied with the plea. I'll accept it. I'm trying to be freely, voluntarily, and intelligently. You indicate you missed them due to some extenuating circumstances. What are those circumstances? Yes.
In the beginning, I had knee surgery, which you were kind of aware of. In the beginning, I was unemployed. My girl, the mother of my child, did her best to help me in the beginning with payments and what she could with drop when it was accessible. She also helped me a little bit with reality counseling. When it was not available, I had missed a couple. I let my PO know and she said I need to hurry up and get my butt a job. I finally, mid-December to late December, finally got a job. But I made the mistake of biting off more than I could chew. My resume stated I was 10 years manager at the subway here at the old at the subway down here in Washington Square. I made management opposed to just a regular burrito artist, and I took out more than I could chew. I lost my mobility and started riding the bus. And after I got the job, I had to be there to be the opening manager, assistant manager by 8 o'clock, Monday through Saturday. And it was hard for me to get from, it takes 3 buses for me to get from my house way north side by the airport all the way to the south side to drop and be to work on time. I didn't communicate enough with my probation officer. And when I finally did, she said, you should have did this a long time ago. I made that mistake and didn't take it into consideration at the time where I should have demoted myself. I worked myself into demotion. I've almost done training my new replacement. And I'm also offered, they told me to figure out what I need to figure out for work, but I've also been offered the store management position if I can just go ahead and do my time and be out within the next 3 to 4 months because they need a store manager. So I'm willing to step up, let the court know that even though I was a victim of circumstance, I did what I needed to do, but I bit off more than I could chew. I'm willing to go ahead and sit down, do my time, and be able to come out as a new man. When I started this probation, it was a problem of my last case that I had in circuit court. I went into a depression mode and started drinking a lot, and that's why I'm here today. I've been doing better. I can't prove it because of my drops have been off. I've only the drops that I did have were clean. Even though, like I said, 9 out of 16 is not a really good number. I apologize for that. But I kind of gave up after a couple. I'm not gonna lie, I gave up on trying to work my way there and try to keep my boss happy. In my brain, I thought if I keep my work happy and my boss is like, "You're doing great," that would help. That doesn't help. It does so much. I became a productive member of society, but they're also offering me a really big raise and everything if I can let this person that I just trained take over the store for a little while. And if I can do my time, if I have to, I will sit down and I want to come back out of productive member of society. My knees back in shape. I got a store I can run. I can keep my family happy. And I honestly, not saying I can't do the probation, but getting a promotion that they're offering me is even biting off more than I already bit off and tried to chew. And I like that new promotion, but they're giving me 3 to 4 months to get my stuff together here and give me the store at $50,000 salary a year. And honestly, if you guys want to give me the opportunity to just go back to do what I was doing and try to work probation out, that's cool. But I kind of would like to be able to come back out. And I'm out of depression mode and I'm ready to be that productive member of society. So if I can just sit down and maybe work something out with them and just do my time.
Work something out with who?
I don't the prosecutor or you or whoever. I kind of want to just sit down, do my time, and come back out.
You want to go to jail, do your time, so you can come back out?
Yeah, I just want to
I
come
was
back out.
thinking that's probably best for you too.
Yeah, just because, like I said, I bit off more than I could chew and screwed myself with probation. They're offering me more than what I already did off, and I'm ready to chew it. I just can't do it without probation.
Okay, you've not been a good candidate on probation. I don't like the fact that you use the term victim of circumstance. You're not a victim of circumstances.
You're right. Yeah, I apologize.
Okay, so stop victimizing yourself based on behavior that you did to put yourself into the situation. You created the situation you're in. And it sounds like even in the midst of that, opportunities are still coming to you. And don't look at the fact that you were given an opportunity to work at a position as a manager as a negative. It's not that you bit off more than you can chew. You can chew it. It may be difficult. There's plenty of people in this room that have gone and navigated through difficult challenges to get to where they were. We don't use our circumstances as an opportunity to victimize ourselves. We make it happen because we're adults, okay? And you're a father, and you have some people that are relying on you, and you need to be reliable. But first, you got to rely on yourself. You've not done well on probation. You are the person who drives that. The court can't make you. All I can do is keep bringing you in and out of here on violations. That's not meaningful to me. It's not meaningful to you. It's not meaningful to the community. It's not meaningful to your family. You don't want to participate in probation. The court's not going to make you. I'm sentencing you to 30 days Ingham County Jail. You'll be remanded immediately to serve that 30 days. There won't be any earned early release or GPS tether release.
Saying, Your Honor, and I'm taking complete responsibility for it, and I appreciate you taking into consideration.
Good luck to you, sir.
Thank you very much, Your Honor. Can I kiss them on the cheek?
Page Elizabeth Smith here. Okay, on the record in the matter of the people of the city of Lansing versus Page Elizabeth Smith, file number 23-00270. Council appearance.
Assistant City Attorney Amani Williams appearing on behalf of the city of Lansing.
The public defender John Lee appearing on behalf of Paige Smith.
Okay, Ms. Smith, today's date that was set for a hearing on probation violations. You were arraigned on those on February 27th. Are we having a hearing?
No, we are not.
Okay, I see the violations alleged that you violated by committing technical probation violations of amended order signed for November 8th, 2023. Formal violations submitted on your sobriety court case in another court. It says violations requested by probation officer Richardson for November 14th, 2023, November 28th, 2023. And it looks like January 2nd, 2024. And you want to plead to those violations?
Yeah,
Is that a yes?
yes,
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
yes, Your Honor.
Thank you. You can put your hand down. Okay, so you have the right to have a contested hearing on your violations. You have the right to require the prosecution, which is the city attorney's office, and the probation department put forth evidence today to establish if you violated your probation or not. Did you want to move forward with your hearing or you want to waive your hearing?
I'm gonna waive the hearing today, Your Honor.
Raise your right hand. All right, I swear you in. Are you sure you want to do that?
Yes,
Okay, anybody threatening you to get you to waive your hearing?
no,
Any promises being made to you in exchange for you waiving your hearing?
no,
Okay, as to the violations, that you violated the amended order of probation from November 8th, 2023. How do you plead?
guilty.
Factual basis, counsel.
Thank you, Your Honor. Ms. Smith, is it true that you were sentenced to a period of probation in case 23-00270?
Yeah,
And is it true that that probation was being conducted at the same time as probation in the Eaton County Court?
yes,
And so the condition and or order of the probation was that you would abide by all the conditions of the sobriety court in Eaton County,
correct,
and that you would not have any violations there.
yes,
And yet, in November and December of 2023 and January of 2024, there were allegations of violations in the sobriety court of 56A in Eaton County, and you pled guilty to those violations, correct?
correct,
And you do not deny them today, correct?
correct.
No further questions.
Any questions from the city?
City is satisfied, Your Honor.
Court is also satisfied with the factual basis. I'll accept your plea and find it to be freely, voluntarily, and intelligently made. I just need to clarify, you're not in sobriety court in 64A, it's 56A?
64, Ionia County, that's where I'm in, sobriety court.
Okay, what's going on? Well, this also says 56A, so that's where you got it from, Mr. Lee.
Yeah.
I'm trying to understand why it says 56A on here, because my note says 64. Okay, so the probation officer must have used the wrong information. Are you on a sober link
Oh, yeah, I have a PBT.
device on you?
Not, it's at home, but it's like a mobile breathalyzer that I blow in the morning
Okay,
and at night.
okay, and so you were sentenced to 3 days jail as
Yes,
a result of those violations?
correct.
And you have another violation pending?
No,
Okay, so the 3 days included the January 2nd, 2024.
It was January 22nd to the 2020, or to January 24th, I'm pretty sure.
That you were in jail?
Yeah,
Okay, but that included the violation from January 2nd,
Correct.
correct? Okay,
Yes.
your probation officer seemed to believe that there might be 3 days more imposed, but I think that might be some confusion on her part, in addition to, she's mentioned 56A 3 times in this recommendation, and I think it's supposed to be 64A.
yeah, sorry
Okay,
about
you
that.
can make, well, it's not your error, it's hers. Okay, you can make your allocution.
Thank you, Your Honor. As Ms. Smith has indicated, she is participating in the sobriety court program. She is utilizing the PBT to confirm daily her status. She did accept responsibility and admit responsibility for where she had a failure. She served her time in regard to those violations and comes here today, Your Honor, humbly asking the court to reinstate her to probation and credit her for her time already served.
Would you like want to make a statement?
Sure. I've came a long way from before when I made those violations. It was a little bit rocky for my probation in the beginning because sobriety court is a lot of things. I've completed MRT, the program. I've completed a Prime for Life program. I do AA 5 times a week, counseling 3 times a week. I've completed over 100 hours of community service already. So sobriety court has been a really great thing for me. I'm working on almost 8 months sober. And if I never was accepted into sobriety court, I never would have changed. So I'm just very thankful for that. And it's unfortunate that I've made a few mistakes in the beginning, but I've served my time. I've done 10 days jail total because it's not my first violation. And it was just a miscommunication, really. I completely just forgot to tell Jody about my violations over here, which caused that trouble.
But these violations are from November 2023 and this January, correct?
Yes.
And those were from you drinking?
No, I had a late PBT. I slept in and I had like a 20-minute late blow.
Oh, okay, so those 3 were all from late PBTs?
Yes, I've had.
But you blew clean?
Yes.
Like Ms. Bayless could have told me that, we could have avoided this hearing.
I think
If she's clean, I don't have to have semantics in this court for that. If it came back drunk, then that's different. All right, well, sounds like you're doing what you need to do outside of sleeping in late. Whatever, you've served your time for that. There's nothing the court's gonna do about that. My goal is to keep you sober, and that's why I essentially amended your probation status here to just follow what you were doing in 64A. So as long as you are making every reasonable effort to do what you need to do there, which it sounds like you are, there's no reason for us to move forward with the violation. I'm dismissing the violation.
Thank you, Your Honor.
You're all set.
Thank you very much. Have a great day.
Same to you.
Thank you.
On the record in the matter of the people of the city of Lansing versus Lachelle Tyler, file number 24-00339. Please see Lachelle Tyler. Okay, council appearance.
Assistant City Attorney Manny Williams appearing on behalf of the City of Lansing.
Public Defender John Lee appearing on behalf of Michelle Tyler.
Okay. And so. I love us. Today's date and the time set for a pretrial. Driving unlicensed. Was there an offer extended on this?
You say again, I'm sorry, I can't hear.
I'm talking to the attorneys, no worries. Today's a pretrial for driving unlicensed. Counsel, was there an offer extended? Williams? I guess she's covering.
Yes, Your
Was there
Honor.
an offer?
Yeah, I'm looking at the note of Assistant City Attorney Gregory Banker. So I believe that
My understanding is no offer was extended. Do you have something different?
yes, the offer is that if she presents a valid driver's license, the charges will be dismissed.
Were you not aware of that offer?
No, nobody had communicated that to me, although I'm not denying that that's not
Okay.
generally standard procedure.
Okay, how do you want to proceed?
Your Honor, I have not yet had a chance to talk with Ms. Tyler. I'm not positive of her status. If we could get a short adjournment, perhaps I can get an update from her as to if she has been able to procure her license since the citation.
Okay, sounds good. Ms. Tyler, did you hear what your attorney said?
I did a little bit, but I didn't hear the end. I'm sorry.
Okay, he is requesting an adjournment so that he can meet with you privately to see if you've gotten a license, okay?
Oh. Okay.
April 1st.
Your next court date is April 1st, at what time?
10:30.
10:30. Do you
Okay,
have any
thank you.
questions, Ms. Tyler?
No, ma'am.
Okay, any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, Ms. Tyler.
Thank you.
You're welcome. Okay, on the record in the matter of the people of the city of Lansing versus Antonio Urdiales, file number 21-01508. No, if he's present. We just joined from an iPhone 3.
There we go. And start video, and there we are.
We just joined from an iPhone 3.
Kiana Wilkie.
Okay, start your video.
Okay, there we go.
2:30. Who's the attorney for Fountain Place?
It's me, Your Honor, Rebecca Austin.
Okay, I'll put you both in a private meeting room so you can see if you can discuss this. Ms. Wilkie, do you have an attorney?
No.
Okay, I'm gonna put you in the private meeting room with the plaintiff's attorney, okay?
Okay.
Let's see, Ms. Austin, if you all can't come to a resolution, you all need to complete a joint pretrial statement, okay?
Okay, thank you, Your Honor.
Okay.
No. Mr. Urdiales is not present.
No, Your Honor.
He previously failed to appear due to being in the hospital, so I'm not sure where he is now. I will issue a bench warrant, but if you hear from him otherwise, we'll quash the warrant. On the record in the matter of the people of the city of Lansing versus Amaria Monet Williams. Council appearance.
Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Public Defender John Lee on behalf of Mario Williams.
Okay, I have file numbers 24-007, 00277 and 278. One is for no insurance, the other is for driving while license is suspended. Was there an offer extended on these?
Your Honor, may I have a brief breakout room with the public defender?
Okay, I can't oblige you on that now. We have a courtroom full of people. So if you all haven't discussed it, I'll just reset the matter. You not received an offer?
No, Your Honor. My understanding was that if she came into compliance, there would be a dismissal. So that's what we've been working towards. And she does, from my understanding, now have a valid license, although I have not yet seen the proof.
Okay, so you need time to do that?
Yes, please.
First at 11.
April 1st at 11. Ms. Williams, your matter will be reset till that time, okay?
Okay,
You're all set for today.
okay, thank you.
You're welcome. Record in the matter of the people of the city of Lansing versus Claude McCullum, file number 24-00547. Is Mr. McCullum present? Council appearance.
Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Public Defender John Lee appearing on behalf of Claude McCollum, who is in the courtroom standing present.
Okay, Mr. McCullum, today's date set for a pre-trial on a trespass. Council, how are we proceeding on this?
Your Honor, we have not yet received an offer on this. We do believe that we can probably get this resolved. Pending further discussion, we probably just need a short adjournment to be able to find a resolution on this one.
First at 11.
April 1st at 11. Have any questions for the court?
No.
Okay, we'll get you a copy of your notice to appear. Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
Nothing for the defense.
Thank you, you're all set. We already did a warrant for McPherson, correct? What did I sign? Which one? McPherson, the one she had in place. You said she's here?
Heather, I think Heather's added another violation.
Oh, I think you have to give me the McPherson file then. I thought you would see me. Report. On the record in the matter of the people of the city of Lansing versus Shaquille Rhyme, file number 21-01039. Okay, Ms. Rhyme, today's the date set for an arraignment on a probation violation. Can you hear me? You need to unmute.
Sorry. Yes, I can hear you.
Very good. I have a request and summons for probation violation. States here that you failed to refrain from the use of alcohol per AverHealth on February 4th, 2024, there was a positive test yielding a result of 1564.88 nanograms per milliliter ETG and an ETS of 1217.36. So you do have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you're found to be in violation, this would be your 6th violation. Your probation would be revoked and you'd be sentenced to jail time. Do you understand that?
Yes.
Okay. Did you want to request an attorney to represent you?
Yes.
The court will enter a plea of not guilty on your behalf, okay?
Okay.
To set it for a hearing, you need to appear in person.
Okay.
April 1st, 7:15.
April 1st at 1:15 will be your hearing.
Okay.
You hang tight. Mr. Lee will be on as soon as he's available to get some information for you to represent you on the violation, okay?
Okay.
Do you have any questions for the court?
No, ma'am.
Oh, thank you. This is, there we go. On the record in the matter of the people of the city of Lansing versus Amari McPherson, I have file number 23-011781. Appearance counsel.
Assistant City Attorney Emmanuel Williams appearing on behalf of the City of Lansing.
Assistant Public Defender John Lee on behalf of Amari McPherson. Mr. McPherson has a heel spur. Would it be okay with the court if he sat?
That's fine. Mr. McPherson, you spoke with him already about whether or not he's having a hearing today, because he was supposed to be here at 1:15.
Yes, we spoke earlier about it.
I have a new request and summons for probation violation. The allegations allege that you have committed the following technical probation violations. It says you tested positive at EverHealth on March 10th, 2024 for alcohol with a result of an ETG 1944.52 and an ETS of 1822.34. So you have the right to have a contested hearing on the violation. You have the right to be represented by your attorney at the contested hearing. If you're found to be guilty of the violations, your probation status can be revoked. You could be sentenced to jail time. It could be extended, or I could impose additional oversight or sanctions while you're on probation. Do you understand that? Mr. Lee, how does your client want to proceed?
Sorry.
How does he want to proceed?
Your Honor, I was under the understanding that he had already pled guilty to these charges, allegations that is, but if not, then yes.
How would he have pled guilty to March 10th and today is the 18th?
Oh, this is a new allegation. That's why I'm misunderstanding. Okay,
It's a new one.
Gotcha.
He was supposed to be here for a hearing on an old one, alleging that he drank, and then now there's a new one. And he's supposed to give me proof that he applied for 10 jobs. Where's your proof?
You said that if I didn't come when I came back, that if I didn't went to the doctor and stuff, then
One
I
or
would
two.
have to start doing application.
Yep, I said you need to provide proof that you were permanently disabled from working, which is one of the conditions you were told you need to provide at the time of your sentencing, or evidence that you've been looking for a job. Which one have you provided? Neither.
My understanding that after, if I didn't bring it, because I haven't been to the doctor yet, the appointments are to the 21st, 22nd, and 23rd.
Was your understanding that after what?
After, if I didn't been to the doctor and had that figured out by then I would have to start applying for the 10 jobs. I do remember you saying that.
Yeah, I didn't say after you didn't figure it out. I said when you come back here. I put this out 2 months for that purpose. You were here in January. It's March. So how does your client want to proceed?
Your Honor, my client reports that he had some doctor's appointments scheduled for early March that got rescheduled till the end of March. He does believe that he will be able to provide the court with proof of his disability. However, in regard to the positive tests, I do not believe, are you denying any of the positive tests? We're not denying any of the positive tests, Your Honor. And we're asking for the court to provide some leniency to allow Mr. McPherson to get his proofs from his physicians. And in talking with his mother earlier, she told me that they are searching and exploring for job opportunities. However, she believes that because they don't want to put any stress on his heart and want to get actual clearance from the doctor, that the types of jobs that they've been finding really aren't appropriate for him. So
From his doctor to drink alcohol.
I believe that that would be the doctor's.
How old are you? You want to plead to the violations that you were previously arraigned on and the one that I just arraigned you on? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you understand you have the right to have a contested hearing on these violations?
Yes, ma'am.
You understand that if you plead guilty or if you're found guilty to be in violation, your probation can be revoked and you could be sentenced to jail time, correct?
Yes, ma'am.
You also understand that your probation can be extended. I can impose other oversight, such as a sober link or a scram tether. You understand that?
Yes, ma'am.
Do you want to waive your hearing today?
Yes, ma'am.
Anybody threatening you to do that? Any promises being made to you in exchange for that? Yeah, I think I missed a violation. Because I arraigned him. On January 8th, I didn't see him in February. There's another violation in here. Allegation is that you tested positive on February 11th at Everhealth with a ETG of 1002.81 and an ETS of 563.16 nanogram per milliliter. Again, you have the right to have a hearing on that violation as well, and you have the right to be represented by your attorney. You want to waive your hearing or have your hearing on that one?
I don't know.
You don't want to waive that hearing? Okay, we can have your hearing.
No, I do want to waive it.
You do want to waive it? Okay. And so you want to enter a guilty plea as to that violation as well?
Yes, ma'am.
Made a factual basis.
Thank you, Your Honor. Mr. McPherson, were you placed on a period of probation in regard to case number 2301781?
Yes, sir.
And as part of that, and that was an alcohol-related offense, correct?
Yes, sir.
And so as part of your probation, you were ordered to participate in random alcohol tests, correct?
Yes, sir.
And do you admit today that you tested positive on February 11th, 2024, March 10th, 2024, as well as what I believe is the previously mentioned dates of 11/11/2023 and 11/16/2020.
Yes, sir.
No further questions.
Any questions from the city?
It is satisfied, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea made freely, voluntarily, and intelligently. The recommendation from your probation officer states here that we should terminate your probation. It's highly suggested that we put you in jail and then have you screened for outpatient. It says the defendant has continued to use substances after reviewing his orders. He is not over 21, so he's not even legal to consume alcohol. Marijuana use went up from November 11th to a November 16th test. It says defendant continues to use and not to take probation seriously, incarceration suggested. Counsel, you can address the court.
Thank you, Your Honor. Your Honor, we would remind the court that Mr. McPherson did in fact obtain his medical marijuana card. But we do not deny that it is an issue that there has been alcohol use while on probation. Mr. McPherson's ability or inability to work aside, we would recommend that the court implement some type of outpatient treatment and or something to help Mr. McPherson find the tools to be able to abstain at least while on probation, and learn to control that part of his life a little better. That being said, Mr. McPherson presents as a respectful young man who is desirous of completing successfully probation and has been battling some very serious health concerns. And so we ask the court to take that into consideration in the sentencing.
Does your client want to make a statement? I can appreciate your argument that you want the court to provide him some tools so that he can address these substance issues, which is the reason we brought him before the court, drinking alcohol under the age of 21. But I can give him right now the tools to go out here and build him a house. If he doesn't want to go build a house, he's just going to have these tools that he doesn't use. I told him to bring me proof that he is permanently disabled from working, because that was what he represented to his probation officer, that he can't work due to a condition. I told him there's plenty of people with health conditions that have jobs. He said, well, the reason why he can't get any jobs that would prevent him from physical exertion is due to the education piece. He hasn't finished his GED, but then I still get him coming here with more violations from him drinking. So you can't on one hand tell me I have a health concern, I can't even do anything because it could trigger my heart, but you're drinking alcohol. He could care less about triggering his heart if he's out here drinking alcohol. I'm positive his doctor didn't prescribe that as a course of treatment. I'm positive that the doctor didn't say you should also mix that with a little medical marijuana or marijuana, and that'll help your situation too. None of these things that he's bringing to me cause me to believe that he has made a conscious decision in his head that he is going to comply with the court order, that he's going to comply with the law, that he's going to make decisions that will put him in a better situation going forward. I don't have any of that. He told me in January that he did have proof of enrollment in the GED program. How's that going?
I'm still doing it. I was just in the back doing the test right now.
You're just in the back where?
Sitting in the back doing the test.
Is the class time scheduled for a certain time of day?
No,
Okay, why were you doing your test in the back of the court?
because usually it wasn't my turn. And some productive while I'm sitting there.
I can imagine that, but you don't work, so why wasn't the test already done?
I do it. It's a practice test until I take the real one on the 25th. But I'll keep practicing.
Okay, so the 25th of this month, you're supposed to take a test,
GED social study test.
social study test? Okay, and how are they grading you? Pass or fail, or are you getting a actual grade?
It's like it's 0 to 200 to score. The highest is 200, the lowest is 0. 150.
And you told me you're advanced placement, so you're getting a 200, correct? Is that a yes?
195, 196,
Okay, when is your test?
on the 25th.
Okay, I'm gonna set this for sentencing. I want you to bring me your grade. I expect it to be, if not 200, as close as 200 as possible. Because I need to see that you're spending your time productively since you're not working and you're drinking. And then we'll address your sentencing after I see what you've been doing in your free time. Is that your mom?
Yes, ma'am.
Ma'am, what's your name?
Akeisha,
Lakeisha. He lives with you?
yes.
Okay. You know that he's drinking? Okay. See,
Afternoon shift. I leave work at 4 and I don't get back to sometimes 4 in the morning.
and he's home by himself most of the time? Do you want to have to take care of him for the rest of his adult life? I didn't think so. Your mom doesn't want to take care of you for the rest of your adult life. So you're gonna have to do some things. You told me you got a really strong head here. I want to see it. I want to see that you're using it. But you can't do that if you're not sober. Do you think you need some help? You do?
Yes.
Okay, we'll get you some help. That's all we need is for you to decide that you need some help. We're going to refer him, well, I'm going to set this for a sentencing. I want you to bring me your test score first. Provided you bring me back a satisfactory grade, I'm the one that's going to decide it's satisfactory, and I'm expecting as close as 200 as possible. I can guarantee you that. If I see that you're making progress, then we will get you or find you some outpatient services. Otherwise, you'll be finding some services through the jail. Do you understand that?
Yes, ma'am.
And I don't think you want to be sitting in jail with a heart condition and a spur issue, do you? No? Okay. Let me get a sentencing date, please. Yes, his test is the 25th. Yes. April 1st. Yeah. April 1st at 1:15 in person. Do you have any questions today?
Yes.
What's your question?
If I take the test, when I take the test on the 25th, I don't know how long it takes for them to grade it.
Okay, he's your attorney. So once you take that test, you call your attorney and you let him know if you got your test results back, and you're gonna call him before the 1st. I've said this before, but it's not a good practice to wait until you get to court at the time of your court date to try to meet with your attorney, because you see what happens when we have all these people that the attorney's trying to meet with. Now we're backlogged.
I had already talked to him before I even got here this morning.
I get it, but you're gonna have to call him beforehand. You're gonna have to call him on the 30th of this month if you haven't gotten a test score. So he could say on the 1st, Your Honor, he hasn't gotten a test score yet. Can we reset this? But that requires you communicating with him, okay? So long as you do that, we'll reset it. You don't have to make a wasted trip here. And we'll reset it to get your test score. Maybe they'll have it, maybe they won't. We hope they will. Okay, do you have any other questions?
No more.
Any additional matters for today's record?
Further, Your Honor.
You check in with your probation officer before you leave, okay?
Yes, ma'am.
Mr. Your other client, Blue, a point what in the jail?
0.122.
A 0.122 in the jail.
My friend?
The one that I remanded.
Oh, yeah. Right.
Are you ready, Mr. Yu? I think this was extra. I don't know what that is.
I have him down as an arraignment.
Oh, okay. Did we see Codeine Sowers?
Yes, she's here.
On the record in the matter of the people of the city of Lansing versus Codeine Sowers, file number 24L284004144243. You can stand next to your attorney. Counsel appearance.
Assistant City Attorney Amani Williams appearing on behalf of the City of Lansing.
Assistant Public Defender John Lee appearing on behalf of Codeine Sowers.
Okay, Ms. Sowers, I have a failure to display ops. I have a seatbelt violation and a unlicensed dog. Counsel, how are we proceeding?
We have requested, sent supplemental requests, that is to the prosecutor for the police reports associated with the aforesaid charges. We've received a citation, but we've received no report. So we would like to see the police report to confirm that stops were valid and, to review the details of the dog licensing issues. And so we will request a short adjournment until such time as we can obtain the proofs.
Okay, so it'll be at least two separate reports you're looking for, as you should have them. Okay, I see one citation, the dog is from December 8th, 2023. And then the seatbelt and licensing issues from February 6th. Okay, okay. And you've made that request to the city attorney's office?
Yes, Your Honor, on the 8th, in regard to the no license vaccination case, and on the 14th in regard to the fail to display a valid license case. We are looking at a global solution to include the civil infractions as well.
Okay, I'll set this out. Next date. April 1st at 10.
Now, will that be for all the cases run? The dog license case and the failed?
I'm resetting all of them, yeah.
Okay.
Ms. Cyrus, do you have any questions?
No. Thank you.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
Hello?
Make sure copy is to appear. Are you driving?
Yes, I was on my way down here. Actually, I'm about to pull over. Sorry.
You can put him in the waiting room. Record in the matter of the people of the city of Lansing versus John Vu in file number 23-01605. Mr. Vu, can you hear me? Mr. Lee, you're gonna get on Zoom?
Yes, Your
Honor. Okay. Mr. Vu, I can't hear you if you can hear me.
Oh, yes, I'm here.
Okay. Today's the date set for an arraignment on a probation violation. I have a request and summons for a violation. It alleges that you committed the following technical probation violations. It says you failed to report to probation back on February 28th, 2024. It states that you tested positive for an abnormal creatine level of 15.9 milliliters and at Albert Health that was at Albert Health on February 1st, 2024, and that you tested positive for alcohol with an ETG of 672 nanogram per milliliter on February 20th, 2024. So you do have the right to have a contested hearing. You have the right to require the prosecution, which is the city attorney's office, put forth evidence that would establish these violations. And you also have the right to be represented by an attorney at that hearing. You understand those rights?
Yes.
If you're found to be in violation of your probation status, it can be revoked. You could be sentenced to jail time, or you could have your probation extended or have other oversight imposed, such as a sober link or a scram tether. Do you understand that?
Yes.
Okay, did you want an attorney to represent you on this?
Yes.
Court will enter a plea of not guilty. I'll note that you're requesting court-appointed counsel. You'll speak to Mr. Lee as soon as he finishes in the meeting room with Ms. Rhymes, and he'll get some information from you, okay?
Okay.
You're hearing this April 1st at 1:15 in person, okay?
Okay.
Do you have any questions for the court?
Not at the moment.
Okay, you're all set. Hang tight and I'll get you in a private meeting room. Okay, Mr. Gibbons needs to meet with is here.
Hello.
What's your video?
I'm here. Can I just come up to the
Water
courtroom?
and light won't even turn on my utilities because
We
they
would
want to
prefer
get,
that.
their water and light's part of this too. Okay. They try to tell me they're not gonna turn.
Mr. Lee? You're not muted.
Pain.
Is there someone in there, Mr. Lee?
Of course.
I apologize, Your Honor. I thought I was muted. I apologize.
Okay, I'm going to put Ms. Rhymes in the meeting room with you now.
Okay.
Is Simon Nolan here?
I'm here on that one, Judge. For plaintiff.
Okay, on the record in Credit Acceptance Corporation versus Diamond Nolan, AKA Diamond Ward, file number 18-02591 GCE, counsel appearance.
Good afternoon, Your Honor. Attorney Ashley Nonis Hartman on behalf of plaintiff.
Okay, today was the date set for a review. The matter was scheduled for 2 p.m. It's 3:08. No one's appeared on behalf of Diamond, Nolan, and or Ward. I see the last order in the court was for installment payment order of $50 bi-weekly beginning December 22nd. The order will suspend the current garnishment that was from January 7, 2023, and I set it for a review within 90 days. Has she been making those payments?
No. So she made a few payments. One of them bounced. She missed 3 payments. So she's $150 in arrears, and then she hasn't made any payments since, and we have no communication with her.
And she's failed to appear in court. How would you like to proceed?
Judge, considering this is the, I believe, 3rd attempt we've tried to give her for an installment payment, I would ask that the court set aside the installment payment order so we can proceed with the garnishment.
We'll set aside the installment payment order, garnishment will issue, and you'll provide an order for the court to review and sign.
I will, Judge. Thank you.
You can submit that through my file.
I will. Thank you so much. Enjoy the rest of your day.
Same to you. I'm trying to help a little bit. Mr. Smith. Who's Mr. Smith? I don't see him anymore. Just going back and forth. Just maybe his thing is jacked up. What's happening here? Whose case is that you're talking about? Brandon Smith. Must be, it might be Judge Janice, because jail wants to know if they need to put him on. Cases. They didn't give me a file number. Yeah. I'm sorry, it should be Brandon White, not Brandon Smith. No, he must have just was arraigned last week, probably. He's right here, actually. We arraigned him on Friday. That's the phone number. Okay, that's all I need to do. Oh, that sounds good. Okay. I don't know what happened to Mr. Smith. I think something's going on with his. Devontae Gibbons?
Right here.
Okay, you have you do have a device because you was just on the phone. Mr. Rusin, you need to meet with Mr. Gibbons privately, okay? So you can see if you can resolve it or come to a joint pretrial statement.
That would be fine, Judge.
Okay, I need you to log back on Zoom. We're gonna get you in a private meeting room, okay?
Thank you.
No problem. Can you show them where they can meet privately with the attorney? Here on Citizens Insurance.
Good afternoon, Your Honor. Kevin Capone appearing for plaintiff Citizens.
Okay, I could barely hear you, counsel. You need to repeat that or adjust your device.
Sorry, Your Honor. I'll try and speak up. It's Kevin Capone appearing for plaintiff Citizens, P number 82518.
Okay, Citizens Insurance versus Terrell Cooper. File number is 23-01-509 GC. Is Terrell Cooper here? Okay, this was a notice of or renotice of hearing for plaintiff's motion to adjourn the trial. Is that what this is for?
Yes, Your Honor.
See where you previously did a joint pretrial statement and we need the trial adjourned.
Yes, Your Honor. So this is a statutory reimbursement action against the defendant pursuant to 3177. We filed their MSD, and I think I believe it's scheduled for the same date as the trial, which is April 3rd. We believe that resolution of the motion for summary disposition will dispose of this case one way or the other. So it's our argument that if we can adjourn the trial 30 days, then we can have a hearing on our motion for summary disposition. Whichever way the court handles that matter will more than likely resolve this case without having to prepare and have the parties prepare for a trial. So this is our first request for an adjournment for trial.
Oh, can you hear me?
So we are just requesting an adjournment of the trial date for 30 days.
Okay, you're requesting, I just want to be clear, you want the trial to be adjourned 30 days after this motion hearing, correct?
Yes, that's correct, Your Honor. Or if the court wants to choose a date that's more than 30 days, if that works better for the court, whichever works better for the court, we are fine with. But if we can just have the motion heard before the trial date, that works better for us, and we believe for all parties involved.
I don't know why they're on the same date anyways. They set it for the same day as a hearing as a trial. Let's see which one we trust. Let me see what I put on this spot paperwork. Maybe this is my fault. Okay, I'm going to grant your motion. You'll get a new trial date in the mail from the civil department.
Thank you, Your Honor. Does the court want me to prepare an order to submit to the court as well?
Yes, please. You can do that under the 7-day rule and through my file.
Okay. Thank you very much, Your Honor. Have a great day.
Thank you. Mr. Smith, can you hear me?
I can, Your Honor.
Okay, let's see. Mr. Smith, you were here on a matter with Angelou Johnson. Angelou Johnson is Angelou Johnson here. Okay. On the record, in the matter of LAFQ versus Angelou Johnson, file number 22-01052 GC, counsel appearance.
For plaintiff LAFQ, Tim Smith, P48259.
Okay, this matter was scheduled for a hearing or actually a discovery examination. No one's appeared. It was set for 2 o'clock. It's 3:18. No one's appeared for Angelou Johnson. I do see on February 5th that there was a request for control date. Did you get the documents that you wanted?
I did not, Your Honor. That's what brings us here today.
Okay, how do you want to proceed?
We'll file a motion to show cause, Your Honor. There's a possibility, we did have a phone call with her since that hearing. She was exploring her ability to pay this off in full. If I don't have either that check or the documents in the next 7 days, we'll file a motion to show cause.
Okay, I'll note that in the file. You're all set for today.
I did have a 130 Juan Centeno, LAFQ v. Juan Centeno. Is that on your docket?
It was not on my docket.
All right.
You have a file number for that?
I do, Your Honor. Let me pull that up for you. File number is 17-247 GCB.
It's before Judge Buchanan. Judge Buchanan case.
Oh, it's Buchanan?
Yes.
All right, we'll hop over there. Thank you. Appreciate your help today.
No problem. Thank you.
You bet.
Back on the record, in the matter of Fountain Place versus Kiana Wilkie, file number 23-06117. Council appearance.
Good afternoon again, Your Honor. Rebecca Austin for plaintiff.
No. Oh, it's an e-file, that's why. Okay, you met privately with Ms. Wilkie.
I did, Your Honor.
There be a joint pretrial statement, or did you come to resolution?
We have not, Your Honor. It's a collection case. We need about 30 days of discovery. The issue was whether or not she gave notice, and she believes notice was given through her Section 8 caseworker. So we just need to kind of explore that, and if that's the case, then obviously she wouldn't owe the penalty rent, and we could resolve it. So if we could just get 30 days to kind of explore the factual background.
I'll reset the pretrial then.
Okay.
April 22nd. April 22nd at 2:30.
All right, thank you, Your Honor. Do we have permission to conduct discovery during that time?
You do.
Okay, and again, I think she's gonna find that and send it to me, and hopefully it'll resolve the whole case.
Okay, sounds good. Thank you.
Thank you, Your Honor. Thanks, Ms. Wilkie.
Thank you.
Okay, let's see. On the record in the matter of Anthony Pryor versus Simon Zaney, file number 23-02133. Council appearance.
Good afternoon, Edward Zaney on behalf of the defendant, Simon Zaney.
Okay, so state your name for the record, please.
Anthony Pryor.
Okay, Mr. Pryor, we reset this matter at the last court date because there was a motion granted for you to file a more definite statement. You see an answer to the complaint in the file as well. Okay, so the parties never completed a joint pretrial statement. Is that accurate, Mr. Zaney?
Correct, Your Honor.
Okay, and I think that there was some contention about your ability to meet privately on that. And we were attempting to do that together when the court decided after reading the complaint on the record that it would be meaningful to have that amended. So this is an issue of a breach of contract, correct?
Yes.
At this time, Mr. Zaney, do you disagree that the pleadings are in order at this point?
Your Honor, we did file a second motion for a more definite statement and alternative a motion to strike. That's been filed via my file. It's reiterating some of the same kind of issue pursuant to the court rules, the pleadings. So as it relates to his amended complaint. But we did file an answer and a counter complaint.
As I said, I do see an answer. You deny the allegation. So you filed an answer and another motion is what you're saying?
I did, Your Honor. And a counter complaint.
I do see the counter complaint as well, which you would need to respond to. Have you responded to that?
I actually, as a response to the court, this is how I received it in my mailbox with no kind of postmarks. Just literally about 4 days ago. I did go through it and I have put together all of my answers to every one of his pinpoints and all the comments that he made in regards to his reasoning behind his thought process in the matter, the attorney's thought process. But yeah, no, I haven't retyped another answer to that already again, because this was, again, how it was delivered.
Okay, what does that mean that it was?
It's never gone through the postal service at all.
But
It's
you
not been
received it.
marked by anybody,
But you did receive it, correct?
yeah, he just shoved it in my mailbox. So
Well, we don't know
Yeah.
who put that in your mailbox.
Correct,
Did you
you
see
don't,
him put
you
it in
don't.
your mailbox?
I'm sure my cameras would, but no.
Okay, well, then you can obviously pull your cameras and see if someone put that in your mailbox. But nonetheless, you did receive it. You've gone through it. You're working on your response. When do you think you'll have a response on that?
Whenever you would like for me to, by the time we get to court for the actual hearing of the,
Well, it's gonna need to be before that. I'm gonna give you 2 weeks from today to file it, okay? You file a copy with the court and then you serve a copy on his attorney.
okay, and can I make mention to the last time that you asked me to type the original complaint? And I believe when I was standing here, you said you would give me till March 1st. And you said, would I have it done by then? And then said 14 days and set it for today's date for the next hearing. I did that. I actually did it at the library. The date I typed it is the date I put on the response. I just want to make mention too, I believe I complied in every way for that. So there was some
Okay, I know
mentions
here
in
that you
this
said
new
I would give
motion.
you 14 days to do that. Nonetheless, we set this to March 18th. You were
Right.
here on February 12th. So the court received your filing on February 28th.
20, yeah, yes, ma'am. Yeah,
And now there's a motion for an even clearer statement. Mr. Zany, you indicate that this is still not clear to you.
Your Honor, yes, to the extent, what are the counts? What are the legal theories? There's a series of facts, but I don't think it's consistent with the requirements of MCR 2.111. As identifying, I know the court started off with, is this a breach of contract case? I can guess that's what it is, but it's not spelled out in his amended complaint to make sure that I'm locking in the necessary affirmative defenses.
Gotcha. I, Anthony Pryor, come before this court in the matter versus Simon Zany. I hired him as a contractor to replace the roof. We initially agreed that it would be 65, is that 100?
yes, ma'am.
Okay, there was no dollar sign. $6,500 labor to Simon in the beginning of May 2022. I started to make payments to Simon on May 31st and was told it would only be a couple of weeks before he could start the job sometime in June. I began to purchase all the materials he told me I need to for the job. I went to ABC and Menards and I made the material purchases. June and July, I was told by Simon, who at the time I considered a long-term acquaintance I could trust, that he was trying to clear up other jobs in August. He reassured me he would be there, thus the $2,500 payment on August 11th, 2022. I was told this time it would before the end of August. It would be, is that what you mean?
Yeah, it would be before the end of August.
Okay, September and October came and went, and I still was being nice and questioned Simon about the completion for winter. He assured me I would have a new roof before winter. Simon contacted me on November 3rd, asking for more money. I told him I would pay when complete. His crew showed up and began working, and immediately when doing tear off, the crew sent by Simon was taking brand new bundles of shingles of the pile of new I had just had delivered by ABC Supply and burying them under tear off debris. The job was to be a complete tear off of the garage and roof and all decking and all the new decking replaced and framed into the structure and disposal of all debris. There was a dump trailer on site, so no need for debris to go into workers' personal truck on top of 6 of my new bundles of shingles. It took them over 3 days to have what they call a complete job. I had to babysit the thieves and direct them to do their jobs correctly. See pictures. They were trying to put new shingles over the decking when I purchased all new decking for both house and garage. Simon said they were complete. He said just some minor cleanup left, and he asked that I pay the balance of, at the time, was $2,000. He assured me that they would come back the next day, so I sent 1,000 more, leaving a balance of 1,000. This was November 24th. He assured again that he would be back by the next day to clean up. Over 2 weeks passed. I then went and purchased insulation for the attic. I have a new roof. I need insulation in attic next. When entering the attic, a mountain of debris came tumbling onto me. See pics. When doing cleanup, I noticed the nails weren't connected to the structure to hold my sheeting to my structure. I eventually cleaned it up myself. He then seen me in public at a local store near my home at 200 North MLK Ave and entered my vehicle violently and assaulted me with a can of Rip It, an energy drink that was new and full and approximately 16 ounce, shaking it and throwing it at me. It hit my dash and damaged my radio display in 2018 GMC, and then grabbed me violently from the passenger side doorway. He entered and tried to yank my arm and pulled me from the driver's side through and out the passenger side of the car. See police report at 200 MLK Ave. I believe this is the police report number.
Yes, ma'am.
Okay. From Robert Olson, LPD, for this incident involving Simon and myself. I am asking the court to allow me to submit my evidence, pictures, and police report, as well as my receipts and estimates from another contract proving in his own words, the roof wasn't completed properly. I have video evidence as well, if allowed. I'm asking for a $5,500 labor paid to Simon, as well as $7,305.48 in materials and my filing fee, as well as a cost accrued. Okay, so the 7,305 is what you're alleging is the cost for the materials for the roof?
For the new shingles and plywood and nails and all the new stuff that I purchased for the roof, yes, ma'am.
And then you paid him allegedly $5,500 for labor?
I did pay him $5,500, yes, ma'am.
This is as very clear as can be. He's not even asking for damages to the vehicle, even though he mentions it in a statement here. I recognize that he doesn't make paragraphs consistent with the court rule, but I have a better chance of hitting the Mega Millions and get him to write a complaint that comports with the court rule. So I'm going to deny your motion for a more definite statement. We're going to construe this as a breach of contract. I'm not really sure. He does mention theft, but I think it's just breach of contract. He's really only requesting money back for what he believes he spent as part of this contractual agreement. And he makes it clear that one is for materials and another portion being for labor. You make a request in your complaint for you to submit some evidence or pictures. You would enter evidence and pictures when appropriate. You don't just hand them to the court. So if we proceed to a trial, you would admit them during testimony. If you're saying that you have another contractor that came in and you're calling him as a witness, because you can't tell me what that contractor said, you would need to have him subpoenaed to court. So we will move forward with the pretrial statement. I'm going to construe the pleadings so far as an order, but you need to respond to their latest response, and you're going to do that within 14 days.
Yes, ma'am.
Okay, due to him needing to respond to the counterclaim, I'm going to reset this out 14 days from today. April 1st at 2:30. April 1st at 2:30 work for you, Mr. Zaney?
Your Honor, I have a pre-planned vacation with my family that week. Could the court do the following week?
We don't do vacations in courtroom 4.
I'm on one now and I'm here, but hey, I could be there on the 1st if you need me to. I'm willing. Whatever the court requires of me.
We'll do another one. April 8th.
Thank you, Your Honor.
April 8th at 2:30.
That's perfect, Your Honor. Thank you.
That works for you?
Yes.
Okay.
Just for the record, I have to have this responded within 14.
You're gonna respond within 14 days. When
Okay.
you draft your response, you will make sure you file a copy with the civil clerk's office
And email it.
and email, because I believe he said he wanted email service and to him, and then we'll see you April 8th. Okay, do you have any questions?
No, not at this point. Thank you.
Okay, any additional matters for the record, counsel?
None, Your Honor. Thank you for your time.
You can wait for a notice to appear though. Thank you.
You also have with us, Your Honor?
Yes, sir. Who's on the shop
Take care.
vote SV 55? Okay, Mr. Rusin, you're finished meeting with Mr. Gibbons?
Yes, I am ready, Judge, to go on the record.
On the record in the matter of LVNV Funding LLC versus Delvante Gibbons. This is file number 24-00376. Appearance for the record, counsel.
Judge, may it please the court, I am attorney Richard Rusin. My bond number is 35222. I'm the attorney of record for the plaintiff today.
State your name, sir.
Gibbons.
Okay, Mr. Gibbons, today was the date again set for pretrial. You did meet privately with plaintiff's counsel. Did you all come to a resolution or do a joint pretrial statement, counsel?
Judge, I have a settlement to put on the record. I discussed the merits of this case with Mr. Gibbons while the case was in recess in the breakout room. The parties have agreed to enter into a consent judgment in the complaint amount of $632.49. I explained to Mr. Gibbons that when these sort of civil actions are filed, there is such a thing in law called taxable costs. And in this case, I pointed out that it costs the plaintiff $55 to issue the summons, and then it costs the plaintiff $35.40 to have the summons served on Mr. Gibbons. The total taxable costs, I explained, were $90.40. I explained to Mr. Gibbons that the state of Michigan, concurrent with the entry of default judgment, grants me as the attorney for the plaintiff a $75 statutory attorney fee. The total consent judgment will be entered in this matter in the sum of $797.89, 797.89. The parties have further agreed that concurrent with the entry of the judgment that there will be a $25 monthly installment payment entered beginning April 1, 2024. And as I explained to Mr. Gibbons before I rest on the record, I now invite Mr. Gibbons to, now that he's heard the record, to give me the permission to sign his name to the proposed consent judgment so that I can email that to the clerk's office for entry on that I rest.
Okay, is what Mr. Rusin said accurate as how you want to proceed?
Yes, Your Honor.
Okay, so you want judgment to enter against you by consent, whereby you'll pay the past due judgment of $632, and I think you said, was it 49 cents?
797.89.
Okay, what's the judgment of the past due amount, not the court costs?
Oh, the past due amount is $632.49. The court costs are $90.40, $75 statutory attorney fee. Total amount is $797.89.
So you want to pay $797.89 in total. That includes the past due amount plus court costs, correct?
Yes, Your Honor.
Okay, and that you're agreed to pay $25 a month installment payment, and you're going to begin that April 1st, 2024?
Yes, Your Honor.
Okay, and so you have the right to be represented by an attorney today. Did you know that?
Yes.
Okay, you want to waive your right to be represented by an attorney in this matter?
Yes, Your Honor.
You have the right to have a trial in this matter. You could have demanded a jury trial. We don't have a jury demand on this matter. Did you want to waive your jury trial so that you can enter into consent judgment?
Yes, Your Honor.
Anybody threatening you to get you to enter into this judgment?
No, Your Honor.
Any promises being made to you? Okay. You have 3 business days from today. If once you leave here, you realize you misunderstood your rights, you can return to the court. You can request to set aside this judgment. Otherwise, should you give Mr. Rusin permission to sign the judgment on your behalf. Judgment will enter in the amount of $797.89, and that you will make monthly installment payments in the interim until paid in full. Do you have any questions for the court?
No, Your Honor.
Are you giving him permission to sign the agreement?
Yes, Your Honor.
Okay, Mr. Rusin, you will submit that through my file, okay?
Yes, I will. Thank you, Judge. On that, I rest.
Thank you. Any additional questions, sir?
No, Your Honor.
Okay, you're all set. Thank you.
Thank you, Judge.
Thank you. Okay, on the record in the matter. Hamilton Road, LTD versus Claude Miller and Betty Miller. File number is 23-01344LT. Can I have appearances, please?
Good afternoon, Your Honor. Gene Turnwald on behalf of Hamilton Road, a representative is seated in the courtroom.
Good afternoon, Your Honor. Darwin Fair on behalf of all the defendants.
Okay, well, this set for multiple things. Let's see, there's a motion. It doesn't make it clear what the motion is for, and then there's an objection. I'm assuming the objection is to the motion. There's a motion to strike filings by non-party Betty Miller for writ to issue and for sanctions.
That's correct.
Okay, and then there was a defendant's motion for reconsideration, which I set for an in-person hearing. There was a Betty Miller who filed in pro per. Is Betty Miller here?
She's downstairs. She can't come upstairs. She has panic attacks and she don't right now. She'll freak out. I'm her son.
Is she in a wheelchair?
No, she's not in a wheelchair.
Oh, we have a stairwell.
She climbed your stairwell back in January, I think it was, and almost passed out.
Okay, well, she's filed this motion to the court, and then I'm assuming she's going to try to appear, I would imagine, in the circuit court or the Court of Appeals, wherever else this case may land. How is she gonna get there? Because I can't proceed without her, and her son can't represent her in court.
Right.
Yeah, Your Honor, if I may, Your Honor, if I may, those.
Oh, Mr. Wait a minute, everybody doesn't get to decide when they may. I'll decide who mays on today. I don't have an appearance from you, Mr. Fair, on her behalf. She filed multiple things since my judgment in pro per.
Your Honor.
Counsel.
It's our position Betty Miller is not a party, never was a party to these proceedings. The court is being intentionally misled by Mr. Fair. The file in this matter happened on January 31st. This court awarded possession to Hamilton Road based in part because the occupants were not the same as the plaintiffs in the Court of Appeals case. Since then, a number of filings have happened that are Betty Miller in pro per. Betty Miller never was a party. Only Claude Miller and all occupants. There was no summons, no complaint ever issued to Betty Miller. She was never added as a party, not once. However, the Court of Appeals case, which is also ironically drafted in pro per, has Betty Miller as a party. So there's a unique advantage adding her as a party after a trial to mislead the circuit court judge. Now, I'd like to back up a little bit. And Your Honor, I know you know a lot of the history of this case already.
I'm sorry, let me stop you. Who are you?
Daryl Davis.
Okay, you can have a seat because I'm dealing with the matter versus Betty Miller at this point that I ordered in person. And you can have a seat too, sir. You can proceed.
Yeah, I'd like to back up and run you through some of this again, just to refresh your recollection. This is a foreclosure. This was an action for possession of a property only that was foreclosed. No payments were made over a year or two. On the very last day, one of the parties contacted my client and asked for a redemption amount. My client stated to them, the redemption period expires today. You're asking to close someday in the future. You don't have enough time. No escrow, no funds were ever deposited. With the plaintiff Hamilton Road or with the Register of Deeds. Redemption funds now are approximately $128,000 or $130,000. We filed a motion to gain the premises on May 1st. On May 21st, and I'm sorry, on June 21st, the defendants represented by Attorney Fair filed a motion to stay the proceedings and also filed in pro per in circuit court a quiet title action claiming that the estate of Betty Miller, Matthew Brown, and a corporation.
The estate of Claude Miller.
The estate of Claude Miller were the actual owners of the property and not Hamilton Road. That was all done in pro per, but I suspect Attorney Fair drafted. I suspect this because we've located very similar cases in the Court of Appeals where Attorney Fair has argued and lost the identical issues. Bryan versus Chase Bank, for example. You can't make a case where you haven't made an effort to pay the redemption funds of $200,000, whatever they have to be, $120,000, and claim somehow you have standing. You don't. You have to pay it either to the plaintiff, Hamilton Road, or the Register of Deeds. And he's argued these cases in the Court of Appeals and he's lost. So we have Betty Miller's name on a Court of Appeals case. It was in circuit court and it was summarily dismissed, identical issue, and they appealed the next day to filed a brief the next day and appealed it to the circuit court. When that hearing finally happens, after it, Hamilton Road is going to ask for sanctions for vexatious pleadings because it's our opinion all this is done for delay. Now here in this case, Mr. Fair originally represented that the defendants in this case were the same parties in the appellate court case. Your Honor discovered on your own, you asked the people to come into court and questioned them and found out that it was the Davises that were the actual occupants of the premises. And Betty Miller has never been a party. We had a trial now on January 31st. After the trial only, for the very first time, Betty Miller started showing up in the caption of the pleadings. And I believe this was done intentionally to muddy the waters so they can argue in front of the circuit court judge that, oh yeah, Betty Miller is now the same party as the Court of Appeals. She's never been a party. She is the only one who has filed an appeal. There is no claim of appeal by the Davises. There is no claim of appeal by the estate of Claude Miller. Only Betty Miller in pro per, but I suspect drafted. I have the motion in order for escrow, and it was drafted by Attorney Fair. And there are several things. What we've also filed an objection to the order for escrow. Betty Miller is claiming an escrow, asking for an escrow. She's not a party, asking for only $1,000. The previous escrow order was $1,600. It was first entered in December of last year. It was discussed at trial. Attorney Fair knows exactly what the escrow amount is, yet he put a lower amount on it. I believe he intentionally tried to mislead the court. Right now, there's $5,600 as of today in arrears. That's not mentioned anywhere. So my first motion, we timely objected to this order for escrow. We'd like it to reflect $1,600 per month and the $5,600 in arrears.
You said there are $5,600 in arrears on the escrow order?
On the escrow. Since filing the objection to bond, you have a 10-day window where you can file objective to bond. This is the only matter that's still in this court because Betty Miller, the non-party, has filed an appeal and no one else has. So on the bond for appeal, her name appears in the caption next to the estate of Claude Miller and all occupants. She doesn't belong to be there.
She told the court she wasn't an occupant.
Well, we never named her as a party, never issued a summons. We'd like her name stricken from the caption so that the circuit court does not get misled by why her name is suddenly showing up in the caption. Because we don't want them arguing, oh yeah, the parties are the same now between the circuit court case and the Court of Appeals case. I've also asked that I've been attorney 33 years. 4 times have I asked for sanctions against an attorney. I believe this court has been intentionally misled by this guy, not once, but several times. And I'm asking for sanctions, if nothing else. You don't have to pay him the Hamilton Road. Pay him to your honor. Uphold the dignity of the court. We shouldn't be here.
Okay. You said your mother's downstairs? Where's downstairs?
In the lobby.
Is it in the lobby? She has a phone?
Yes.
Okay. Did she log in? Because someone is on a shock vault and they're not, I don't know who it is. And I removed them, but they tried to log back in. We don't know who it is.
Okay. Go down there.
Yeah, she needs to log into Zoom. Because she doesn't have an attorney on this. Mr. Fair, who are you here for?
Well, Your Honor, I just want to make clear what cases we had before the court. My understanding was a motion for reconsideration and a motion to strike.
Correct, but they weren't to strike anything that you were on.
Well, okay. Well, we responded to.
I'm trying to understand why you're here. I don't have any recent filings from you.
They were rejected, Your Honor, by the file.
The motion to strike, let's see. We answered the motion to strike, and that is what I thought that I would be arguing today. Also, I could speak to the issue of reconsideration, but Judge, if you don't want me to speak to it, that's fine.
Well, you can't,
But
because you gotta, if you're gonna represent someone, you need to file an appearance, and you can't do what I suspect you're doing, which is try to hide behind the 8 ball and draft motions for someone to file on their own and then show up to court.
Well, no, Judge, I would never try to mislead the court like that.
You want?
Okay,
I'm gonna ask her under oath when she gets here if she drafted this.
No, Judge, it has it right here that it was done with the help of a lawyer. I did help her as a lawyer. It has it on the pleadings that must be in the pleadings that the document was drafted with the help of attorney. It has it right there in her motion for reconsideration.
Okay. Primarily, it was drafted with the help of you, correct?
That's correct, Judge.
Okay. Again, I'm not clear as to why in one regard you want me to believe that you represent all the occupants, is what you said, but then you appear when it comes to a representation for her on this matter, because I don't have anything in my file that was filed from you I don't have anything.
Okay, Your Honor, if I may, and I know that this is.
You said it was rejected?
It was.
It looks like your filings were rejected through the My File system, so you likely did not file them appropriately.
Okay, so Judge, let me respond to that. If you saw my response to the motion to strike, I addressed that specifically. What happened is
I don't want you to read me your motion, because this is already a very convoluted case, and I think that it's become more convoluted than it needed to be, because I don't believe that people are being as forthcoming as necessary. I had to order everybody in here and specifically request who lives in this property and who doesn't. This is a landlord-tenant case. We are here to liquidate a property. We're not here to quiet titles. We don't address titles in this court. If you get an order from another court telling us that we can't move our case until that issue is resolved, then we do that. We've not got that in this matter. You're well aware of that, because we've gone through that multiple times. I'm not going to reconsider that position.
Well, I'm not
This is a
asking.
landlord-tenant action.
Yeah, I'm not
You've
asking the
not,
court to.
and you've not filed any general civil action against Hamilton Road in the interim to help, in this court at least, to help your client's interest, whoever your client is. I'm not clear. I don't know if you represent Mr. Davis. I'm not sure who you represent. Who do you represent,
Judge,
Mr. Fair?
Judge, if I may, Judge, if I may. We were going to file the motion for reconsideration. We were told that we were, for whatever reason, removed from the case. And we spoke to the clerk and they said it was inadvertent. And so what we did is, as quickly as we could, file the motion for reconsideration under Betty Miller, who is now before the court. But the reality of it, Judge, and not to put form over substance or make a distinction without difference, Betty Miller.
One moment.
Okay.
I have to mute Miss Miller until, if you can stand there. I know her son is there assisting. If you stand by, I'm muting her because you're in the lobby and there's background noise, and it cuts off what Mr. Fair is saying. So I'll let you know when you can unmute her. Okay. Okay, you can proceed, Mr. Fair.
Okay, so the key is, Judge, the key is Betty Miller is the presumptive owner of the subject property. It is her husband who was on title, but she is his wife. So she is the presumptive owner of the property. She is the one who filed the lawsuit I'm the one who filed the lawsuit in circuit court for Betty Miller and the other defendants in that case. Then there was
I understand all of that. I've heard this probably 20 times already. I'm very clear. Did the circuit court grant you the relief you were seeking?
No, they did not. That case is currently before
and
the
you now are appealing that decision of the circuit court, correct?
Yes.
Okay. Has any court granted you the relief you were seeking?
What you mean in the circuit court?
You said it's before the Court of Appeals?
Yeah, they have not ruled on the case.
Has any court given you an injunction to prevent any other court from moving until that happened?
Well, you have, Judge, with regards to the district court, when the district court gave possession to the plaintiff, and there was an appeal to the circuit court. And as a result of the appeal, there's an automatic stay to the circuit court. And that is what is in place right now. And that appeal.
From my understanding is we're here because of the, was there a bond posted? I thought that there was an issue with the bond being posted.
Well, that was before the court now, Judge. That's the motion for reconsideration for the bond.
That's what I thought. There was no bond posted. So you got to post a bond in order to appeal.
Well, Judge, that is what is currently before the court. She's asking the court to reconsider its decision for the bond because she does not have the ability to pay. And that's number one. But number two, there's an escrow order that my clients are attempting to comply with. But there's another little twist here, Judge, that I found out yesterday or the day before yesterday, in which the plaintiff sued the tenants at this property and got a default judgment against them for rent. So they're on the one hand has a default judgment against the defendant for rent, and on the other hand, they want escrow for the same property, and it's for the same property. But that aside, she doesn't have the ability to post a bond. The house, is in and of itself is enough to protect the plaintiff. And number two, they can pay the escrow. There's this question of whether it's $1,000 or $1,600. We called the clerk's office. The clerk office said it's $1,000. And I'll tell you why, Judge. the last time we were in court, this whole issue of an order that occurred on the 19th, where there was obviously misunderstanding on everybody's part, and this court said, well, disregard the order for the 19th. And I think that's why the clerk says the order is still only $1,000 a day, $1,000 a month. Now, if the court wants to change it, I mean, that's fine. But from the clerk's, what they told us is only $1,000 a month. But having said that, Judge, I think the key is that Betty Miller is the presumptive owner of the property. There was this court made a determination that the plaintiff has possession, and so there was an appeal within 10 days. So the court rules are real clear. If there is an appeal, then the possession is stayed pending the outcome of the appeal, and that appeal is still pending. Only question now is this whole issue of bond, and that's what she wants to argue to the court, that she doesn't have the ability to pay. I would love to argue that, Judge, but we had to file it in pro per because the clerk's office took my name for whatever reason off of the file. And so we had to have them re-put our name back for the file because I've always represented all the defendants in the district court. Now, I don't think I have to necessarily argue this motion for reconsideration because the issue is not really so much me, it's the issue of Betty Miller, and does she have the ability to pay the $5,000, which she does not, but she can tell the court herself that she doesn't have it and ask the court to not have her have to pay the $5,000, to allow her to appeal according to the court rules. The court rules are real clear with that, and then allow her or the whomever these defendants are to pay the escrow. But then that's why I want to point out to the court to be clear that Mr. and Mrs. Davis have been sued for rent for that property. So it's like the plaintiff is double dipping, or it's not electing its remedies. But having said that, Judge, I think the key is that you questioning Miss Miller and asking her if she can pay the $5,000, and if you're going to allow her not to have to pay the $5,000. If she's forced to pay the $5,000, obviously that's a problem for her. But I'll let her speak for herself.
So you've already spoke for her.
Oh, thanks, Judge. But Judge, I just want to make it clear. There's no real misunderstanding here. You have Betty Miller, who sued in the circuit court. That case is before the Michigan Court of Appeals. She is, when you talk about this property in the district court, it's still Betty Miller. She is the presumptive owner of the property. The Davises.
No, we're not dealing with ownership here. We're dealing with possession.
Yes. Well,
we're not dealing with ownership.
Well, no, I get
and
that.
She
Judge.
came to the court and she let us know that she did not reside in the property.
No, I get that, Judge. There's no question she doesn't reside in the property. But if you evict the tenants, she's the one who suffers as a result of the owner. And I hear what the court is saying.
I completely understand your position.
Okay.
You believe that the foreclosure was invalid and she should be the lawful owner of the property. Until the court says that, she doesn't get to act like the lawful owner of the property. You got to get a court to make her the lawful owner. You can't, by virtue of filing lawsuits, make her the lawful owner of a property. And that doesn't stop our eviction until or unless another court, a higher court, stops it. And you've not presented that. There's no court that told us, well, we got to review this issue. Look, you pause what you're doing over there. That never happened. In fact, the circuit court dismissed your claim and you're now appealing it to the circuit court. And so I recognize what your position is, but you've not provided the court with sufficient basis whereby they can stop an eviction matter because you have an unrelated circuit court matter being appealed at the Court of Appeals.
No, Judge. No, that's not the legal basis. The legal basis is the court rules in the district court, which says if the court in the district court,
Mr. Ferris,
let me finish. Let me
him get it out.
The court rules are real clear. If the court gives possession to the plaintiff, which it did, And then if the defendants appeal to the circuit court, it's an automatic stay. And then there's
I
an
get that
order
part.
to-
I wasn't talking about that. I was talking before we got here. I recognize
Yeah, okay, I'm
the
sorry.
appeal, and
Yeah,
that's how we got the bond on appeal. They are appealing. I set a bond, and they want me to reconsider the bond, or do they want me to reconsider? Ms. Miller, you can unmute now because I need to ask you since you filed this info first.
Your Honor.
Give me just a moment, please. Can you help her unmute, please? Or do I have to send you a request to unmute? Okay.
Thank you.
Thank you. Ms. Miller, can you hear?
Yeah, I can hear.
Okay, and so you filed a motion for reconsideration?
Yeah.
Okay. You're not sure what you filed?
I was at the court, but I don't know exactly, no.
What motion was it?
Okay, what motion was it?
A motion, it says defendant's motion for reconsideration.
Well, yeah, for that $5,000 you talking about?
Yeah, well, you filed a motion, it says on the 7th of this month, addressing the escrow and then also the $5,000 for the surety, a bond for the appeal, correct?
Yes.
Okay, and why did you file that motion?
Well, I guess it wasn't doing anything, so I was wondering what was going on about that and why we would have to pay the $5,000.
Okay, well, it was typical that you would need to post a bond for an appeal. I'm not sure why you were addressing the escrow because you don't live in the property, do you?
No.
Okay. And the escrow order was asked to the occupants of the property. Were you aware of that?
Yes, not me.
Okay.
Yes,
so
he had said, he had told me about it. Yeah.
Okay, how did you file this motion?
In the court.
You filed it in person?
Yes, I was downtown, yeah.
Well, I'm asking you because you haven't been able to come upstairs. So did you go to the 5th floor to file this?
No.
Okay, so how did you file the motion?
I didn't sign no papers.
I'm sorry?
I went to the one on Kalamazoo Street. I went to the courthouse on Kalamazoo Street.
Okay, but this month,
and that was on the first place. I don't remember that one.
You don't remember filing any motion here?
No, I didn't sign no paper here, no.
Oh, okay. Did maybe an attorney sign file one for you here?
Yes.
Okay. You wanted to address the court?
Your Honor, a claim of appeal was not timely filed. We're being misled on that. The trial in this matter was January 31st. Your Honor signed a judgment landlord-tenant on February 16th. We have 10 days from February 16th, according to the court rules, that Mr. Fair wants to argue to file a claim of appeal. They didn't file one. They filed one on February 12th, before Your Honor even entered the order. That's entirely improper. It says an appeal from the order must be filed after the order is entered, not 4 days before. And it really comes down to Betty Miller is simply not a party to this proceeding. Why are we adding her to the caption? It is a misdirection. It is intended to confuse the circuit court the same way he has confused Your Honor and myself. So that's what he does, and that's why they're all done in pro per, because ultimately they lose. He's argued the same cases, same issues, Court of Appeals, and lost.
I understand. your position, and I've heard his position multiple times. Betty Miller is not an occupant for this landlord tenant. And I've said that multiple times. So I can't accept or continue to accept pleadings and filings from someone who was never a party, an interested party in this. Why, Mr. Fair, whether you help her draft it or not, that's not going to change the fact that she's not an occupant. She's told the court multiple times that she's not an occupant. And this was a possession case against the occupants of the property. This matter is not about of the property.
Judge, I hear the court loud and clear. That's why also Mr. Davis is there also, and he can address this issue of his inability to pay the $5,000. He's not filed an appeal, nor has he filed a motion to post a bond. Well, he's not done any of those things. Well, first of all, let me say with regards to the appeal there was a supplement to the appeal, so it was timely done, and it was done after the final order. So that appeal is currently before the circuit court. And if the court, you know, I judge, I believe me, I hear what this court is saying loud and clear. I do. And from our perspective, it's one party. It is one party that is. I understand your perspective. Okay, I don't need to hear anymore. Okay, I'll address the motions. There was a motion to strike the filings by non-party Betty Miller for writ to issue. That motion will be granted. Betty Miller is not a party in this matter, nor was she ever an occupant in this eviction landlord-tenant proceeding. So that motion will be granted. The motion for reconsideration is not properly filed. Betty Miller can't file a motion for reconsideration for the occupant, Mr. Davis, being evicted. If you want to represent her or help her improper to file a motion or a action in another court to stay this eviction pending her court of appeals, that's different. But you can't attach her to this matter the way you've been doing it. It's improper. I'm tired of the filings. I'm tired of the back and forth. I'm tired of having to find out who lives in the property, who doesn't. I don't want to see this case anymore, to be quite honest with you. I'm not going to sanction you at this time, but I can guarantee you I won't be as nice the next time I get one of these filings. Okay, if the court wants me to file appearance on all these cases and change the pleadings with regards to who lives there and who doesn't, Judge, Judge, I'll be more than happy to do that. I will. Well, you represented Mr. Davis the entire time, supposedly, because your original appearance was for the occupant, which was Mr. Davis. It was never for, it was not Miss Miller. She was not a party. And because she was not a occupant in this property. You represented Mr. Davis. You could have filed your bond as it relates to Mr. Davis, or an appeal as it relates to Mr. Davis. That's not what you did. Judge, I hear you, Judge. I do. I could amend all those pleadings if you want. No, we're not going to play that game, because you're just like Mr. Turnwall said. He's been an attorney for was it 3 decades? I think that you have been an attorney probably a comparable amount of time. And you're well experienced. So I think you knew that if you were representing him, then you can appeal for him. That's why you had Ms. Miller file improper. That's my personal opinion. I 100% believe that you are trying to play a game as it relates to who filed what pleadings. Because even if the clerk's office inadvertently removed you as a party, they have to put you back on, because you always represented the occupant, Mr. Davis. At least that's what your appearance stated, so that you could file any motions as it relates to your client. But that's not what we got here. We got something from Ms. Miller. We got multiple filings from Ms. Miller. Then you appeared. That's not appropriate. Again, the position of the court has and will be, if you get an order from another court, whether that be the circuit court or the court of appeals, that tells this court that they need to stop any liquidation of the property because of a pending action in their court that would affect the liquidation,
this court will follow that order, but that's not what we have. You're trying to attach someone to this case who's not supposed to be attached to this case to get that order outside of doing it the appropriate way. So for that reason, the motion of reconsideration is denied.
Yeah, Your Honor,
Yes.
will the court give me an opportunity to go to the circuit court to request an order that would be appropriate for this court to consider with regards to the current occupants of the property?
We gave you opportunities since September. What are you talking about? Mr. Turnwell argued multiple times that you need something from the circuit court that would stop this. You never brought it.
No, Judge, no, not from the circuit court with regards to the circuit court case, but the circuit court appeal that was just filed. And with regards to the circuit court, the circuit court.
You're talking about the appeal you're talking about the appeal of this case by Ms. Miller?
That's correct.
Mr.
Well,
Davis,
yes.
Mr. Davis has to appeal. Ms. Miller is not a party.
Judge, and that's why I said we will amend all those if the court will allow us to, because and I know you don't want to hear my argument anymore, but I think you know my argument, and you know, I just want to make sure, and I know the court understands our position is a distinction without difference. However, saying that, if the court wants me to
the court didn't hear anything you said, because the Polycom times out after we've been on here for so many hours, and apparently we've been on here for over 9 hours, so it booted us out. And so you need to restate your statements.
Well, what I said to the court is, if the court wants me to redo the captions of the pleadings with the circuit court appeal, that would include all the parties, will be more than happy to do so. I understand
the court doesn't want you to do anything. The court's just telling you that as you filed it, it's being denied.
No,
I don't want you to do anything. I want you to do whatever you feel is necessary to zealously advocate for your client, so long as it comports with the law and the court rules. That's all I want you to do. And I also want for you not to tie up my docket with matters that are not appropriately filed. That's all I want.
And Judge, I agree with you wholeheartedly.
Your Honor, we'd like the writ to issue. The occupants have not appealed. There is no proper appeal from this case. Appeal in this file. Betty Miller, as your court ruled, is not a party. No bond has been posted. There's $5,600 in arrears. We'd ask the court to issue the writ immediately.
$5,600 is the arrears for the escrow?
For the existing escrow order in district court.
Judge, I don't know how it could be that high. They've made, my understanding, they've made the payments, except for maybe a couple of them. And the order was just entered.
In our motion, we itemized, I can read the itemization into the record.
Please.
October 2023, 1,000 was paid, 1,600 owed. Deficiency 600. November 1,000 paid, 1,600 owed. Deficiency 600. December 1,000 paid, 1,600 owed. Deficiency 600. January 1,000 paid, 1,600 owed. Deficiency 600. February nothing paid. March nothing paid. That as of March today.
Okay, and your dispute, of course, Mr. Turnwell, is that your belief or your client's belief is that the escrow amount was supposed to be 1,000 and not 1,600?
The escrow amount was supposed to be 1,600 based upon our motion for reconsideration that was granted and entered in December 19th, 2000.
Well, I mean, not to interrupt, but Judge, that's the order that you said.
Give me a moment. Give me a moment,
Okay.
sir.
I'm sorry.
Yeah, say when it was changed. No. Yeah, it's to say when it was changed. Let's see.
I have the order, Your Honor.
You have a copy of the signed order?
Yes, I do. It was just here. And well, Judgment, we made it as a, here's the one that Your Honor changed to immediate writ. May I approach?
You may. December 19th.
There's a motion for reconsideration of the existing order. It was granted.
Yeah, for some reason, the civil department has it as $1,000.
Well, Judge, let me tell you why. Because when we were at the last hearing, you know, and we can obviously, this is my recollection, as you said, disregard that order.
It's not true at all. It's not on the record. And we even had to play back some of the Zoom record to Mr. Fair.
You're talking about this hearing was here January 31st, correct?
The trial was January 31st.
Right. And
During
that's
the
when
trial.
This is the date that I signed this. That's the date that I signed this. It's date stamped January 31st.
Because you changed the existing order. You said the existing order shouldn't have the immediate writ portion. That was entered under the 7-day rule. And you pointed out that Mr. Fair should have noticed it. And you crossed out the writ portion, but you left the $1,600 a month reconsideration order intact. I then had discussion with Mr. Fair after the trial, actually had it with my secretary, and informed him that what the existing escrow funds were. He knows all about it.
Well, no, Judge, Judge, the only thing I can say is this whole issue of $1,600, where he's made reference to the 600, 600, and 600. The court didn't enter this order until the 31st.
It was a motion for
That's
reconsideration.
Okay. My notes said on November 21st, 2023, I granted the motion. It said the defendant failed to appear. And that I amended the escrow to $1,600, and I lifted the stay of eviction due to defendant not filing with the circuit court for a stay. And so I granted their amendment to the escrow. That's when you were supposed to submit the order under the 7-day rule. So I see where this was filed. And let's see here. We amended it to December 19th being the date on here. That's
the writ portion was amended on December.
Correct. I see that here because we did have a hearing on December 19th. And I crossed out the November on here, put December on there. And then date stamped, I guess, when I further amended at the next court date on January 31st. I date stamped in and signed it for January 31st, crossing out the writ and eviction shall be issued within 10 days. So I do see that, but it does say here that was not crossed out. You were here, sir, on January 31st. You were aware of this order, and it says that the escrow was changed from 1,000 to 1,600. It says that on here. So what is your argument? Your argument is about how many months back we're going to go on that? Is that your question?
Yeah, well, that number one, Judge, and I can tell you your clerk's office is saying it's $1,000.
The clerk's office made a mistake. My order, the court speaks through orders and not clerk's offices.
Right, and I agree with that, Judge. But my client is attempting to balance, I guess the best way to describe it, between going to the clerk's office and being told one thing and the order saying something else. But having said that, it's not $5,600. It is at most March, and my clients will bring that current, whatever the court says that is, forthwith. But it's not $5,600.
You mean it's at most March? What does that mean?
Well, I don't have a copy of when escrow payments were made. But the only point I'm making is if the court is saying that as of January 31st is $1,600, then that means in February, my client has to start paying $1,600. And whatever the court
from December.
Okay, Judge,
this is the order from December. So that means January, February, March, he would have paid $1,600.
And Judge, Judge, whatever the court decides today of what the arrears is, it is, and I will ask my clients to make that payment. Best I can say forthwith. If you give them 10 days, I know they can get it in by then. Because of this unclarity of exactly how much the escrow is, but it's not $5,600. That's the point I'm making.
Well, it's not that. I think that the escrow amount was always clear based on the order, and you represented Mr. Davis, so you got that order. You even addressed the court at the next court date about the concern in regard to the writ being issued within 10 days of the order. That's the only thing you addressed, though. We didn't address that escrow, or that was not crossed out at that time. The only thing I addressed on that, so you were aware of the order under the 7-day rule on that escrow being amended from 1,000 to 1,600. I can't speak to why the clerk's office did what the clerk's office did, but we'll make sure that's addressed. I would take the position that at the bare minimum, there should have been a $1,600 payment February and March, though.
Okay, Judge,
your client's raising his hand. Did you want him to say what he needs to say on the record?
Okay, all right, Judge. Okay, he can say what he wants to say.
You have something you want to say, Keith?
I
Mr.
do owe
Davis?
February and March 1,600. That is correct. I did receive something on it. The problem I have is I was sued for 11,000 in rent, so I don't know when those are or what that is. So,
okay, you were sued for 11,000
for back rent.
For back rent and for a money judgment. Is that what you're suing him for?
Yes, Your Honor, from
That's why I
May
was confused on where
until
to pay.
October.
And who's that before?
It was for Your Honor. He never answered the pleadings. The default he was issued.
There was a default.
Issued the
My son had
complaint,
passed away. I
summons,
missed it.
default happened, you missed.
Did you file a
We then
motion to
had a
set aside
debtor-
the default?
No, Your Honor. We then
No,
had a
the-
debtor's exam.
I didn't.
The debtor's exam is
Judge-
scheduled this week, Your Honor. It's the
Yeah,
second
Judge,
one.
I just found out about it. And when I talked to my client about it, he thought that this was part of the same case. And he was wrong, Judge. And I just
That's
found
not
out
true
about
at all.
it. But
He's appeared
no,
at
no,
the
let
debtor's.
me
He
finish.
appeared at the debtor's exam?
Yeah.
A few days ago, yes.
Okay.
And they got
Judge,
moved to the 20. I was
I
confused.
can-
Yes.
Okay.
I can file a motion to set aside the default judgment. And what's the point? The point is the plaintiff is in effect double dipping. On the one hand, he's
That's
asking for
absolutely
rent,
not
and
true
the other
again.
hand, he's asking for escrow.
Okay, well, you should file your motion, please. You're representing him, so you need to file the motion. And if you have an attorney, when you get stuff in the mail, why are you confused? You call your attorney and tell him I got this in the mail.
Your Honor, that wasn't his fault or
No, that's your fault for not
My
calling your
son
attorney
passed away and I
when you got
missed
something.
everything. He passed November 9th.
I'm sorry to hear that.
And I know that's no excuse for anything. My
The
mental.
default is 3 or 4 months old. It's already too late to file a motion to set aside. The debtor's exam.
No,
The first.
no, it's
scheduled
not.
If I owe the money, Your Honor, I owe the money. I mean, that's
You missed-
fine. I
this is
told
from
Mr.
May.
Carter-
Okay, what's going on in here?
It's from May until October.
Okay, if that's up to Mr. Fair, if he wants to file a motion for his client to set aside the default, and the court will make a determination after said motion. We're not going to tell him he can't file a motion. He can do that if he wants. You talk to your client as it relates, or to your attorney as it relates to that. I don't know what's being sought in that judgment. I couldn't speak to that. But your attorney will file any necessary motions as it relates to that. We're going to deal with this matter. You agreed that you owe February and March for your escrow, correct?
Yes, ma'am.
He's not disputing that. The itemizations that you're bringing, I think, go back to October, though.
That's when the original order for escrow was entered, and this was a motion for reconsideration.
But
of
he
that
paid
original order.
$1,000, and
Yeah, and I asked the court, and the court agreed in November, the rent should actually be 1,600 at least.
I get that. I'm not. If I made you believe that it was my intention to retroactively.
That was a motion for reconsideration, is why I considered it.
I recall that, but my understanding is that I did not go back and reconsider the past amount. Moving forward, I will increase it. I will not go back and
Even then,
make
Your
them
Honor.
pay $600 for months that had passed.
Even then, the order was agreed to entered in November.
I recognize that. Well, my record said it was entered in December.
Okay, the actual finally got signed in mid-December, so there's at least December, January, February, March.
Well, I agree
So
with the court. Judge.
He hasn't paid anything in March?
No.
Okay, so he owes 600 from January, 600 in February, and then 1,600.
In my opinion, a minimum 1,600 December when the order was signed, January 600, February and March 1,600 each. So now we're at.
I'm not going to order December because I think I signed it December 19th.
Then there's January 600.
January 600, February 600, and
February 1,600.
1,600.
March 1,600. So we're at, I can't add.
Well, he paid something in February, no? Oh, you didn't pay anything in February. I thought you said he paid 1,000. Okay.
3,800. But I'd ask the court to issue the writ immediately. Doesn't mean we have to act on it. But no party in interest appealed this case. Only Betty Miller. I mean, that's very clear by the court file. So where is the stay? What is the reason for the stay? 10 days from judgment, and the judgment was entered February 2024.
But Judge, I don't want to.
No appeal has been it.
Judge,
we're a charade, the whole thing.
What we've talked about before.
Okay, I've already entered or stated what my ruling was. Any further banter is just between the two of you all. You all can get each other's phone numbers and knock each other out if you want to go back and forth. I don't need to be here for that. I don't need to be a party. I'm positive that you're going to put in a request for a writ. I'm positive Mr. Fair is going to go and file a motion to stay the writ and then file another filing. I'm positive that we're not done yet. I'm positive of that. But nonetheless, as it relates for today, there will be a order for a writ to issue, and I will note on the record that the bond appeal, let me find this motion to reconsider. Motion to reconsider the bond appeal is denied as Betty Miller is not an appropriate party in this matter. And can you provide an order for that?
Okay.
Okay.
And Judge,
under the 7-day rule.
Under the 7-day rule, and my understanding, Judge, that you're giving us an opportunity to clean up what needs to be cleaned up. I guess that's the best way to describe it. Because what will happen is that Mr. Davis will file the motion for reconsideration for the $600.
Like I said, I can't stop you from I can't prevent anybody from using the court for what the court is here for. And so if proper motions are filed, the court will address them. I can't prevent that.
Your Honor, to be clear, the motion to strike is granted. Betty Miller's name is removed from all the pleadings.
Correct.
The motion for reconsideration is also struck.
No, Judge, you haven't.
The escrow order should reflect that $3,800 are in arrears and need to be paid immediately, and also the bond. Well, the bond stays the same at $5,000. And Betty Miller is the only party appealing, and non-party appealing. And we've already filed a motion to dismiss in circuit court for that nonsense.
Okay, Judge, the motion to strike, I have not had an opportunity to respond to the motion to strike because you said we're only dealing with the motion for reconsideration. She shouldn't be struck.
I addressed the motion to strike. I granted it today. I don't know where I said it on the record. Well, you would not have had, you wouldn't have, why would you need to respond to the motion to strike when you weren't representing her? I'm not following.
Well, Judge, I put in the motion to strike that I was representing all the parties. But having said that, if that's the court's ruling, that's the court's ruling.
Okay, so again, I've stated that the motion to strike was granted. Again, the bond amount or the reconsideration on the bond is denied. I'm gonna get an order under the 7-day rule. And then we'll see Mr. Fair's next filing and the writ shall issue immediately.
The writ shall issue immediately.
Correct.
Thank you.
Judge, you're not going to give us an opportunity to clean up what the court believes to be cleaned up before a writ actually files, because if they're evicted.
What the court doesn't need to clean up anything. That's you who needs to clean it up.
No, and I agree with that, Judge. But the point of it is, are you going to have them evicted in the interim?
This matter has been pending for I don't know how long. If you want to go and file something, you know how to file a motion to stay a writ.
Yes, I will file a motion to stay the writ, Judge.
Thank you.
Thanks, Your Honor.
Maurice Jordan.
Thank you, Your Honor.
Maurice Jordan.
Yes, ma'am.
Oh, okay. What matter was he supposed to be here on? Sir, do you have a kid? Oh, you were supposed to be here at 11 o'clock today?
I thought he said 1:30.
It definitely doesn't say 1:30, and it's definitely not 1:30 right now. You have an attorney?
Yes.
Did you speak to your attorney?
I spoke to him last week. I'm still trying to get that plate. I got another vehicle, but for some reason they keep giving me the runaround for the death certificate for my cousin.
Gonna reset your matter. April 1st at 11.
Okay, thank you very much.
Make sure you write it down accurately. We're gonna send you another notice to appear. Show up at 11.
Yes, ma'am.
Okay, sir. You're all set.
Thank you.